of the Court of Appeal at Kisumu and was the chair of the Judiciary Committee on Elections, a standing committee of the Kenyan judiciary that is charged with the responsibility of overseeing the efficient disposal of election matters by the courts. As President of the Supreme Court, Chief Justice Maraga presided over 2 presidential election petitions in 2017. Under his leadership, the Supreme Court of Kenya famously nullified the election of incumbent President Uhuru Kenyatta, becoming the first African court to annul a presidential election in August 2017. Malawi became the second African country to do so in February 2020. He also determined numerous election petitions and appeals during his tenure as a judge of the High Court and appeals in the Court of Appeal, as well as in the Supreme Court. Chief Justice Maraga is a recipient of honorary doctoral degrees from Daystar University and Adventist University of Africa in Kenya, as well as Andrews University in Michigan, USA, all in recognition of his distinguished service and courageous leadership. Chief Justice Maraga has also received numerous awards in recognition of his defense of the rule of law, among them the International Commission of Jurists, ICJ Kenya Jurist of the Year, the CB Maiden Award in 2017, the Law Society of Kenya Award for Distinguished Service in the Administration of Justice in 2018. In 2016, the head of state honored Chief Justice Maraga with the state honor of the Elder of the Golden Heart in recognition of exemplary service to his country. Chief Justice Maraga is a Christian and an elder of the Seventh-day Adventist Church. He is married with 3 children who I'm pleased to say are all here with us today. Justice Maraga's lecture is entitled Africa's Emerging Constitutionalism and Democracy from the Prism of Presidential Election Petitions and its relevance to growth and development. There will be an opportunity to ask questions by posting them in the Q&A box on the bar below. So please wait for the lecture to complete and you'll have the opportunity to post those questions. Justice Maraga, karibu sana. I now invite you to give the inaugural CLA Africa Hub public lecture. Thank you.
Thank you very much, Linda, for the opportunity and honor to address such a distinguished audience. And before I start, I would like to make a disclaimer and request that you oblige me. In my mother tongue, there are some letters of the alphabet which are missing. As a result, sometimes my pronunciations are different from what you are used to. Where I'm supposed to use L because it is not there, sometimes I use R, and I beg that you bear with me. Thank you very much. We can start. It is common knowledge that the independence constitutions of most African countries embraced the doctrine of separation of powers that mainly focused on securing the sovereignty of states and setting up the governance machinery. However, soon after independence, the African leaders jettisoned the concept of constitutional implementation and instead embarked on consolidation and the vesting of all state power and authority in the executive arm of government, in particular the presidency, which in Kenya is referred to as the Imperial Presidency. The Kenyan executive firmly controlled the other arms of government, including the judiciary, which was an appendage of the executive arm and subordinated to a section of the Attorney General's office. The ensuing regime did not tolerate any form of opposition, prompting constitutional scholars like Ben Nabwese and Okoth Ogendo to Christianize that regime or those regimes as having constitutions without constitutionalism. The collapse of the Berlin War and the end of the Cold War significantly reshaped the world's geopolitics. The post-Cold War changes and the third wave of democracy that challenged the status quo led to regime changes across the developing world, especially in Africa and Latin America. On the African continent, the political regimes of the African strongmen ended abruptly, ushering in broad political and constitutional reforms across the region. Some of the reforms included entrenchment of the separation of powers and the establishment of independent judiciaries, as well as the vesting of courts with explicit roles to adjudicate and determine electoral disputes, which had been a huge challenge for many years. Prior to those constitutional reforms, elections did not have any intrinsic value in most African countries. Instead, they were periodic rituals, which were basically legitimacy codes for leaders who wanted to project a facade of democracy. In extreme cases of military takeovers, elections were abolished and the constitutions were suspended. Despite those fundamental reforms, there is no doubt that that elections and the democratic processes in many African countries have generally been less than satisfactory. Of the tens of petitions filed over years across the African continent challenging presidential elections, all but two, the one of Kenya in 2017 and Malawi in 2020, were dismissed for one reason or the other. In all those other cases, the election of the incumbents or the ruling political parties was sustained by the courts, often under circumstances that elicited controversy and dissatisfaction. In one particular instance, the judiciary nullified the election of an opposition candidate and instead declared the incumbent who had lost the election to have been validly elected. That elicited controversy. That trend elicited controversy and dissatisfaction and even violent conflicts. In Kenya, for instance, lack of public confidence in the judiciary to impartially and effectively resolve the dispute arising from the 2007 presidential election led the opposition politicians to resort to street demonstrations and riots instead of filing court action. The ensuing violence, as most of you know, claimed more than 1,300 lives and displacement of another 250,000 people. The jurisprudence that has emerged from the courts over the decades seems to disproportionately favor incumbent regimes, which has elicited sharp criticisms of courts' decisions, leading to many to questioning the independence and impartiality of the courts. Critics have in particular accused the courts of hiding under technicalities in the adjudication instead of adjudicating the real issues in the election petitions. What challenges or factors have contributed to this pattern? What is the cause of lack of public confidence in the judiciaries? Is there something the courts are not appreciating or are ignoring? Are there aspects of the election petitions that council representing the parties are not properly or adequately articulating? This presentation is not a critique of or a criticism of any court decision. In an attempt to respond to these questions, this presentation briefly examines the import of the constitutional reforms in adjudication of presidential electoral disputes and the emerging jurisprudence on the African continent. Though I suppose the majority of those participating in this webinar are lawyers, please allow me to make some obvious remarks to lay the basis for my presentation and for the benefit of those who may not be lawyers. In that regard, before delving into the core arguments of this presentation, I will briefly comment on the role of the courts and the place of elections in a democracy and the significance of presidential elections in Africa. I have already pointed out that among the fundamental reforms arising from the post-Cold War changes and the third wave of democracy is the entrenchment of separation of powers, which is the backbone of any democratic constitutional system. The doctrine is based on the division of powers among the three branches of government, with each of them being limited in its sphere of authority. As Aaron Barak of the Israeli Supreme Court wrote, and I quote, "The three branches of government are of equal status. None of them is omnipotent," end of quote. Each has its specific role to play. While Parliament makes laws and the executive implements those laws, the role of the judiciary is to adjudicate disputes alleging infractions and to enforce the law. The discharge of the judiciary said role, in the discharge of the judiciary said role, the election judge is required to always remember that the purpose of law is to regulate societal relations, and his duty is to help the law achieve that purpose. The judge is required to always remember that the law of a society is a living organism based on a factual and a social reality that is constantly changing. And that without changing a statute, the judge is required to give its provision a dynamic interpretation that seeks to bridge the gap between the law and the social reality. In a democratic society, the judge's role is to defend democracy. In discharging that role, the judge is required to always remember the tenets of democracy and the place of elections in a democracy. President Lincoln's definition of democracy during the famous Gettysburg Address as a government of the people, by the people, and for the people still holds true. Democracy is a system of government that bases its legitimacy on participation of the people. Though respect for human rights, the rule of law, separation of powers, and the existence of a transparent, responsive, and accountable government are critical pillars of a democratic government, in my view, elections are the soul of any democracy. Free and fair, competitive elections are the foundation of every healthy democracy, ensuring that government authority derives from the will of the people. Creative elections not only confer government with legitimacy, but also sustain democratic order. As such, elections are viewed as a legitimizing process that grants the elected leaders the wherewithal to govern. Legitimacy, on the other hand, is grounded on the constitutional concept that governments derive their just powers from the consent of the governed. It denotes the people's approval of the rule or a ruler above them and their obligations towards that rule or ruler as their subordinates. Acceptance by a society's majority that their government is legitimate makes the social order more efficient, consensual, and just. If a government is not considered legitimate, it will find it hard to even regulate order in society. I do not need to go into examples of society's reviews or to accept the legitimacy of a regime to govern them, but to only refer to what is happening currently in Myanmar. I don't know how to pronounce that that name. This Asian country which has a problem where the military have toppled the elected president. That brings me to the importance of the presidential elections. In the adjudication of presidential electoral disputes, the courts must never lose sight of the importance of the presidential election. The judge is required to always remember that presidential elections, as one writer has characterized them, are extremely high-pressure events. Why is this so? In any constitutional democracy, especially in Africa, a president wields immense powers. Besides being the head of state and the commander-in-chief of the country's defense forces, the president defines and sets the political, social, and economic vision of the country. Deliberate policy choices and the decisions made by the president have an impact and the bearing on the socio-economic situation and developmental needs of the country's populace. A presidential election also provides the electorate with an accountability mechanism. It provides the electorate with an opportunity to reevaluate the performance of the incumbent president seeking the election and consider his or her further developmental agenda to determine whether or not he or she deserves another term. For new entrants to the arena, a presidential election provides the electorate with an opportunity to show how they will outperform the incumbent. If none of them has anything better to offer, a free and fair election will enable the electorate to shut them out. The electorate is hoping for an improved standard of living, get very agitated about presidential elections. Those factors significantly raise the stakes of a presidential election and renders it the most important election in any country. The judge is therefore required to always remember that if presidential elections are mismanaged or candidates do not respect and adhere to the rules of the game, if the average citizen, political parties, and the candidates do not perceive them as free and fair, elections can lead to eruption of conflicts with the debilitating consequences on the socio-economic, political, as well as the cultural welfare of the individual nations. The 2007-2008 post-election crisis in Kenya and in Cote d'Ivoire in November 2010 provide good examples. In the circumstances, the judge is supposed to always remember that the proper management of presidential elections, including resolution of any dispute arising therefrom, is of crucial importance to both the stability and the prosperity of his or our nation. As such, courts are required to put in place tools and measures that can guarantee a legal and political legitimacy of their decisions in presidential disputes. Because by their decision, they legitimize or demonize an electoral process, the judges handling presidential petitions are supposed to ensure that justice is not only done, but is also seen to be done. Before I discuss the tools and measures that the courts are supposed to put in place in the adjudication of presidential election petitions, let me conclude this part by briefly examining the mandate of the judiciary in the adjudication of presidential electoral disputes. Besides providing for an elaborate Bill of Rights, including the second generation Bill of Rights, among the critical reforms introduced by the Kenyan Constitution 2010, and of course those of other countries, include the unequivocal statement on the source of governmental authority, and as stated, the entrenchment of an independent judiciary and the doctrine of separation of powers. On the source of governmental authority, Article 1 of the Kenyan Constitution provides that all sovereign power belongs to the people of Kenya and shall be exercised only in accordance with this constitution. Article 2.4 is unequivocal that any act or omission in contravention of the constitution is invalid. Article 1 sub Article 2 delegates the exercise of that power to the three equal arms of government: the executive, the legislature, and the judiciary. With regard to judicial power, Article 159.1 states that judicial authority is derived from the people and vests in and shall be exercised by the courts and tribunals established by or under this constitution. Part of the judicial authority vested in the judiciary is the resolution of electoral disputes. Article 140 vests the Supreme Court of Kenya with the original and exclusive jurisdiction to resolve all presidential electoral disputes. Article 872 vests the High Court with jurisdiction to resolve all other electoral disputes. This is clear judicialization of politics. By judicialization of politics, I mean the reliance on courts and judicial means for addressing core moral predicaments, public policy questions, and political controversies. As Professor Kwasi Prembe observes, this is not a power or authority that the judiciary has arrogated to itself. Rather, the people to whom the radical title to state power and authority belongs vested their judicial power in the courts as a result of the lived realities that to avoid conflict, the legitimacy of the electoral process requires the imprimatur of the court. As Prembe adds, without express invitation by frustrated or ineffective legislators, judges would not have inserted themselves in the electoral process. There is therefore no second guessing anymore. With this explicit constitutional judicialization of politics, the court should dismiss the politicians' nebulous contentions based on the counter-majoritarian principle that as the judges are unelected, they have lesser legitimacy than officers of the other political arms of government, and that under the political question doctrine, that courts are prohibited from adjudicating political and policy controversies, that the political branches of government are better suited and equipped to resolve. The people saw it fit that those controversies should be resolved by the judiciary and not the politicians. So the questioning of the judicial authority has no basis whatsoever. This judicialization of politics is also a common feature in other African countries. Judiciaries in Africa are now, by dint of express constitutional or statutory edicts, authorized to resolve electoral disputes. They have no option but to resolve them. What does this vesting of the authority entail? The vesting of the people's judicial power in the judiciary entails a recognition that although the choice is that of the electorate, the ultimate determination of the legality and the legitimacy of the electoral process is vested with the election courts. As such, the election courts must never lose sight of their judicial authority as the ultimate custodians of the Constitution in general, and in the context of this presentation, the electoral justice. This behoves the courts to give holistic and dynamic interpretations to the provisions specified in the Constitution and the election laws. And in doing so, they must always uphold the will of the people in election disputes brought before them. They must never saddle the people with an individual who the electorate has rejected. On this operational basis, I now wish to consider the doctrinal tools the election courts use in adjudication of electoral disputes. As stated earlier, despite the constitutional reforms entrenching judicial independence and the vesting of courts with explicit roles to adjudicate and determine electoral disputes, presidential election petitions filed in Africa, and I should add, in other developing countries, hardly see the light of day, thus triggering public condemnation of the judiciaries, and in some cases, violent political conflicts. This, in my view, cannot be allowed to continue. What then should the courts do? What should counsel appearing for the parties in electoral disputes focus on? You will recall I stated earlier on that the purpose of the law is to regulate societal relations, and the judge's role is to help the law achieve that purpose. That the judge is required to always remember that the law of a society is a living organism based on a factual and a social reality that is constantly changing. And that without changing a statute, the judge is required to give the provisions of the law he or she is considering a holistic and dynamic interpretation that seeks to bridge the gap between the law and the socioeconomic and political reality. In my view, therefore, the courts have to relook at, and in the prevailing socioeconomic and political reality, assess the relevance of the tools they have in the past used to resolve the presidential election disputes. The African judiciaries must resharpen the doctrinal tools they have used in the past to determine those disputes. In other words, for justice to be seen to be done, for justice to be done and be seen to be done, the courts should, where appropriate, reverse their previous decisions and decide cases on the basis of the prevailing circumstances. In this regard, I now wish to flag out aspects of electoral jurisprudence that I think require examination. In this presentation, I wish to discuss 4 doctrinal tools. And using the Kenyan case of 2017, demonstrates how they can be used to properly adjudicate electoral disputes on the continent. The 4 doctrinal tools are a re-examination of the settled principles, a recalibration of the burden and the standard of proof in electoral disputes, a reformulation of the substantive effect tests, And lastly, a proper appreciation of the technicalities versus substance in election disputes. The effective adjudication of disputes requires not only nuanced approach to the above doctrines, but also judicial courage and determination to do what is right. After discussion of the four doctrinal tools above, I will briefly discuss the effect of attacks and the intimidation of the judges handling presidential electoral disputes, and the salient duty of the courts and the judges in those circumstances. I will start with the settled principles, or rather the so-called settled principles. In one of the judgments on a presidential electoral dispute, a judge is quoted as stating that in many jurisdictions in Africa, the court does not, and I quote, readily invalidate a public election, but often strives in public interest to sustain it, end of quote. In judgments from other jurisdictions, including Kenya, there are statements to the effect that election results declared by the electoral commissions, and I quote, enjoy a presumption of regularity. In other words, they are prima facie correct, and the onus is on the petitioner to prove the contrary, end of quote. Knowing as I do the blunders the electoral commissions commit, all I need to say on this is that in my respective view, such as statements have no further place in our electoral jurisprudence. As stated earlier, with the explicit judicialization of politics, the ultimate determination of the legality and the legitimacy of the electoral process is now vested with the courts. Across the second aspect I want to touch is the onus of proof, the onus and the standard of proof. Across the African continent, basing themselves on the law of evidence that he who alleges must prove, the election courts have developed a principle that in all electoral disputes, the burden of proof rests with the petitioner. That's the way it should be. But there is, however, some disquiet on this. The argument being that as the electoral materials which petitioners often require to establish their cases are always in the inaccessible custody of the electoral commissions, the latter should shoulder some burden of proof. The proposal in this regard is that after the petitioner has established a prima facie case, the burden should shift to the Electoral Commission. In its judgment at paragraph 33 of the Kenyan Supreme Court, the Kenyan Supreme Court succinctly propagated this principle as follows. And I quote, once the court is satisfied that the petitioner has adduced sufficient evidence to warrant impugning an election, if not controverted, then the evidentiary burden shifts to the respondent, in most cases, the electoral body, to adduce evidence rebutting that assertion and demonstrating that there was compliance with the law, or if the ground is one of irregularities, that they did not affect the results of the election. In other words, while the petitioner bears an evidentiary burden to adduce factual evidence to prove his or her allegations of breach, then the burden shifts and it behoves the respondent to adduce evidence to prove compliance with the law. At paragraph 410, the court concluded, and I quote, in keeping with our pronouncement regarding the burden and the standard of proof in election petitions, we are therefore satisfied that the petitioners have discharged the legal burden of proof as to squarely shift it to the first and the second respondents. We are also of the firm view that having so shifted, the burden has not in turn been discharged by the first and the second respondents to raise substantial doubt with regards to the petitioner's case. Excuse me. I would recommend this principle for adoption in other jurisdictions. Once a petitioner establishes irregularities in the conduct of an election, the petitioner should not be required to produce evidence, to provide evidence or any further evidence that those irregularities did affect the election. The Electoral Commission and all the other respondents should thereafter assume the burden and prove that the irregularities did not affect the election. The standard of proof has also generated some controversy. The electoral courts have established a general principle that electoral law is neither civil nor criminal. It is sui generis. And on that basis, the courts have settled on a standard of proof to the satisfaction of the court on infractions that are of a civil nature and beyond reasonable doubt on allegations of a criminal nature. Though I have myself applied this standard of proof in many electoral disputes, upon reflection, I agree with the critics that there is no legal basis for that categorization of the electoral law, that the electoral law is sui generis requiring such a high standard of proof, especially on infractions that are of a civil nature. This approach may partly be the cause of the failure of many election petitions in Africa. There are many cases which have elements of both civil and criminal law, but have not attracted such a categorization. In cases with allegations of fraud, for example, which is a criminal infraction, a standard of proof higher than a balance of probabilities is adopted, not one beyond reasonable doubt. In one case, the Kenyan Court of Appeals stated that principle as follows: it must always be remembered that allegations of fraud must be strictly proved, so that while a standard of proof beyond reasonable doubt is not required, nevertheless a standard more than a mere balance of probability is called for, end of quote. I see no reason why this standard that is higher than a balance of probabilities and not proof beyond reasonable doubt should not be adopted in respect of all allegations of a criminal nature in election petitions. I say this because the election court is not a criminal court. It does not conduct a criminal trial and convict or acquit the persons alleged to have committed bribery, corruption, or assault in the case of in the electoral process. As the Supreme Court stated in the 2017 case, the determination of criminality of such allegations is left to the other agencies. In all allegations of civil nature, therefore, the standard of proof should be on a balance of probability like all other civil cases. The other aspect I want to comment on is the substantive effect rule. And this is quite important because quite a number of cases have been dismissed on the basis of this, on this rule. Commentators on presidential election jurisprudence argue that the application of the substantive effect rule embodied in Section 83 of the Kenyan Elections Act and elections of other countries in prima materia should be carefully considered. The Kenyan Section 83 of the Elections Act reads, no election shall be declared to be void by reason of non-compliance with any written law relating to that election, if it appears that the election was conducted in accordance with the principles laid down in the Constitution and in that written law, or that the non-compliance did not affect the result of the election, end of quote. It is clear this provision has two limbs. The first limb is concerned with compliance with the principles laid down in the Constitution and other election law, while the second limb provides for avoidance of an election when non-compliance affects the results of the election. Before considering it, I think it is important to point out that hardly any two of the African election statutes that I was able to access as a similar wording of the equivalent provisions. Their provisions use the conjunction and instead of or. A lot of comment has been made on this provision, and opinion is varied on its application. The controversy on the interpretation and application of the provision is mainly twofold. First, whether or not the two limbs should be applied conjunctively or disjunctively. Secondly, whether or not the effect referred to is qualitative or quantitative or both. Some of the commentators of the provision assert that despite the or and conjunction separating the two limbs, the two limbs should be applied conjunctively. Others are of the view that they should be given a disjunctive application. The origin of this provision, as we know in Anglophone jurisdictions, is the English Representation of People's Act of 1918. The modern version of it is the English Representation Act of 1983, which reads, and I quote, no parliamentary election shall be declared invalid by reason of any act or omission by the returning officer or any other person in breach of his official duty in connection with the election or otherwise of the parliamentary election rules, if it appears to the tribunal having cognizance of the question that number A, the election was conducted as to be substantially in accordance with the law as to the elections, and B, that the act or omission did not affect its results, end of quote. Save for Kenya, as I have stated, all the other African jurisdictions have the conjunction and not or in their statutes. Despite the conjunction and used in the English provision, in the famous case of Morgan versus Simpson, Lord Denning held that the two limbs should be disjunctively applied. He succinctly propounded that one, if the election was conducted so badly that it was not substantially in accordance with the law as to elections, the election is vitiated irrespective of whether the result was affected or not. If the election was so conducted that it was substantially in accordance with the law as to elections, it is not vitiated by a breach of the rules or a mistake at the polls, provided that it does not affect the results of the election. Number three, if the election was conducted substantially in accordance with the law as to elections, but there was nonetheless a breach of the rules or a mistake at the polls that did affect the result, then the election is vitiated. A reading of many of the judgments from the continent indicate that the second limb of the provision is what is causing a great problem. In my view, irrespective of the conjunction are, and, or, in any of the statutes with this provision, I agree with Lord Denning that the two limbs of the provision should be applied disjunctively. The point cannot be clearer than how Lord Denning put it in the third of his above strands, that if the election was conducted substantially in accordance with the law as to elections, but there was nonetheless a breach of the rules or a mistake at the polls that affects the results, the election should be vitiated, irrespective of whether it was conducted substantially in accordance with the law. Some judgments seem to just suggest that the substantive effect is only quantitative, so that if the irregularity does not affect the numbers, then the results should be, the election should not be dismissed. In my view, that is not a correct appreciation of the provision. If the irregularities committed in the conduct of elections, the irregularities committed in the conduct of the election can be quantitative, qualitative, or both. An example of the quantitative effect is where, as in the case of Morgan versus Simpson, the irregularities, if proved, can wipe out the winning margin. An example of the effect, qualitative effect includes irregularities committed which put into question the integrity of the entire electoral process, as was the case in the 2017 case in Kenya, where the failure to simultaneously electronically transmit to the National Tallying Center the election results from the polling stations rendered the authenticity of the declared results indeterminate. In my humble view, the qualitative criterion should be applied in all cases where there are allegations of bribery, violence, and or intimidation, unless those allegations are localized and the sum total of the votes from the affected polling stations cannot affect the result, even if they are all assigned to the petitioner, the election should be vitiated. In all the other cases where the allegations of violence and intimidation are made and proved against the security forces under the control of the incumbent, his or his election should be vitiated unless, as stated, they are localized and they have no effect. Have no known or seen effect. The other area I want to discuss is the one of technicalities. The argument here is that the courts have dismissed some cases on technicalities. One of the, one argument that was put across, has been put across, is that the election court in Kenya ignored the numbers and instead decided the case on technicalities. Those who care to look at the law will see that Article 81 provides for free and fair elections in an electoral system that is transparent and free from violence, intimidation, improper influence, or corruption. Article 86 requires the voting system used in an election to be simple, accurate, verifiable, secure, accountable, and transparent. Can infractions of these provisions be characterized as procedural irregularities committed in the course of conducting an election? I do not think so. So those arguments that the judges ignored, the majority of the judges ignored the numbers and they decided the case on mere technicalities, in my view, have conveniently avoided to mention that the said electronic transmission was a compromise reached and enacted into Section 39 of the Elections Act after protracted negotiations between the ruling and the main opposition parties. Say for isolated instance, in polling stations in Kenya, the Kenyan elections on the polling days are generally peaceful. The Kenyans go to the polls, queue for long hours, and cast their votes. The problem is always in the counting and tallying of the ballots. The allegations have always been that the Electoral Commission and some interested parties tamper with those results during the counting and the tallying process. So to address this anomaly, the Elections Act has been amended on a number of occasions, including requiring that the results be declared at polling stations, those of the polling stations. In the 2017 case, a majority of the Supreme Court found that transparency and verifiability are among the constitutional principles enshrined in Article 86 of the Constitution and referred to Section 83 of the Elections Act. They further found that without the electronic transmission, it was impossible to verify and vouch for the authenticity of the election numbers. Accordingly, it held that the failure to electronically transmit the results was not a mere irregularity, but a violation of the constitutional principles guiding the conduct of elections. It further found that even if to electronically transmit the results was regarded as a procedural irregularity, it affected the integrity of the results and accordingly nullified the presidential petition. The other interesting jurisprudence arising from the cases is the timeline set for filing and examination of the presidential election petitions. Critics have categorized these as irregularities and faulted the courts for adhering to them. In my view, this censure is not entirely correct. The historical background to the timeline limits should not be ignored. In Kenya, for instance, a good number of the election petitions, including the presidential petitions, pended in court for the entire parliamentary term and lapsed by mere a fraction of time, and thereby, properly in my view, triggered public outrage against the judiciary. To correct that anomaly, timelines within which election petitions should be filed and determined were put in the Constitution. With regard to the presidential petitions, the law requires that they should be filed within 7 days of the declaration of results and determined within 14 days of filing. I agree with the Kenyan Supreme Court that these and other timelines set in the Constitution are iron-cast constitutional imperatives that cannot, by graft of interpretation, be extended. With regard to other situations, once a petition is lodged in court within the prescribed time, I agree with the commentators that it will be raising procedure to a vest and fail to do substantive justice when an election court strikes out for failure, a petition is for failure by the petitioners to themselves sign the petitions, failure to serve the petitions personally upon the respondents, failure to file the documents out of time, and other such irregularities. In such situations, the court should do as much as possible to accommodate the parties and determine the election petitions on merit. The last issue I wish to comment on is the attack and intimidation of the election courts, which commentators claim have a sway in the determination of the presidential election petitions on the continent. When politicians lose elections, election cases, they question the authority of the courts to make such decisions in the first place. In other instances, the initial winners who praised the judiciary on their first court victories, change sides and attack the courts when they reverse those decisions. In 2017, the 4 judges who annulled the presidential election petition were viciously attacked and intimidated by the president and the east side of the political divide. The opposition National Super Alliance, led by Honorable Raila Odinga, who was the petitioner in the election dispute, praised the judiciary and rebuked the president for threatening the 4 judges of the Supreme Court. Odinga and his associates boycotted the fresh election held on 26th of October. And after the court dismissed the second presidential petition filed by individuals, it was Raila's turn to attack the Supreme Court. He asserted that the Supreme Court judges were cowards who bowed to intimidation and upheld the President Kenyatta's re-election in the fresh poll. Indeed, with politicians, as the saying goes, you are damned if you do, and you are damned if you don't. The people having vested the courts with powers to scrutinize and determine the fairness of elections, judges have no choice but to carry out their constitutional role. It is inevitable that by their decisions, judges are thrust into the center of the partisan politics. As such, public attacks on judges who preside over election matters erode the constitutional basis of the rule of law. In my view, and I would urge that the public should be vigilant and protect the judges when they are attacked in such circumstances. In conclusion, I would like to reiterate that the office of the president, as I have noted in my earlier remarks, determines a lot of fundamental issues in the country's governance and the developmental process. This in turn makes the adjudication of a presidential election petition a critical and an important part of the country's democratic process. Accordingly, I urge all stakeholders in the presidential dispute resolution process to never lose sight of the enormity of the dispute at hand. Given the short timelines in the hearing of the petitions, counsel representing the parties in those cases should prepare thoroughly and plead their entire cases at once to avoid or to obviate applications for leave to amend or file documents out of time. Because of the ramifications it has on the stability and the socioeconomic and the political welfare of the country, the election court's decision on a presidential election dispute is equally the most important piece of litigation in any country. Courts must never forget that a poor handling of a presidential election petition can easily plunge the country into chaos. Accordingly, even when they are threatened, the judges must never succumb to pressure, intimidation, or any other form of undue influence. Indeed, judges have no business occupying their coveted positions if they cannot withstand such pressures. Their positions are not for the timorous and the faint-hearted. Instead, they should firmly but fairly uphold or dismiss presidential petitions depending on the facts placed before them. Thank you very much, ladies and gentlemen, for listening to me. I hope I have not exceeded too far the time I was allocated. Thank you.
Thank you very much, Chief Justice Emeritus. That was an excellent presentation. I'm sure everybody agrees. As stated earlier on in the introductory remarks, people have been posting questions in the Q&A box, and I will now go through a few of them. Maybe if you can answer 3 at a time, and then we'll take another 3. So we have anonymous attendee who says, thank you. Very useful information, even for those of us who sit in political dispute tribunals. What would you say is adequate time to allow for a presidential election petition process, taking into account the time limits in Kenya, Uganda, Malawi, and I would add Zambia, in which you have to hear and determine the case within 14 days. And I would also add, given that there's a high threshold for in terms of the burden of proof. The second question comes from Saidu Umagumi. My lord, in the common law setting, the recognized standards of proof on the balance of probability and proof beyond reasonable doubt, how can an intermediary standard be created to take care of election matters? Maybe it's related to the first question, in fact. And the third question comes from Barrister Josephine Ijekuhemen. I'm sorry if I butchered that. In a case where the election was conducted by the law and the winner was disqualified as a result of some technicalities, how can the court justify pronouncing a candidate who amassed fourth votes as a winner, maybe the fourth person who came fourth? This is an example taken from the Supreme Court of Nigeria decision in Imo State, where the present governor was pronounced as the winner by the apex court. My question is, how can the court justify this decision? Can it review itself upon a fresh application? So if you could take those first three, and we'll take some more later.
Thank you, Linda. The first question is about the timelines, the reasonable timelines for determination of these disputes. I agree with those who have commented that the time allocated for the Kenyan disputes, I think Kenya, is it Zambia and Zimbabwe? 14 days given to the judges to hear and determine the petition is inadequate, completely inadequate. We have made proposals in the past to the Kenyan parliament that this period should be extended to 30 days. But it should always should be remembered that where the constitution requires that the disputes be resolved before the president is sworn in, the time is definitely going to be short. And in that case, I would recommend 30 days. On the second question, the one inquiring, Saidu, about the intermediate standard or intermediate standard of proof. That's the one I said in the circumstances of the election petitions, we should have a look at that and and change the standard of proof. In allegations of a civil nature, it should be a simple proof on a simple or a mere balance of probabilities. Mm-hmm. Where the allegations are of a criminal nature, then the standard should be one slightly above the balance of probabilities, but not to the extent of beyond reasonable doubt. The other question touching on the election in Nigeria talks about a huge, or a huge winning margin, and yet the election is nullified. I would say that the election is not only about numbers. The election is about a process. If the numbers have been arrived at by an illegal process, or a process which does not verify those numbers, the court has every right to nullify that election. It is upon the electoral commissions to ensure that the procedure is followed, so that when the numbers are reached, the winner is given his victory. But when the numbers are, it is not clear how those numbers have been arrived at. And they may very well be as a result of violation of the law, the election should be nullified. Thank you.
Thank you, Chief Justice. And maybe as a follow-up to, you mentioned that in some cases where there's a criminal element to the presidential petition, the standard of proof should be higher. We have a question. I'm not sure who the person who asked the question is, but they say where the commission of criminal acts has been proved using the standard you recommend, when should other agencies move in? Is there a lacuna in the law that leaves criminal offenses in elections to go unpunished? There's an anonymous question here, and I think it speaks to your earlier submission that if you're damned if you do and you're damned if you don't. It says, do you sincerely believe that a largely boycotted election amounts to an election as envisioned under the law? Do you think that the two decisions by your court in 2017 left the electoral system in confusion after setting the high standard? With the same breath, you set very low standards. And number 3, from Bernard Ekemu in Uganda. In some African jurisdictions, the powers of the executive greatly outweigh the power of the 2 other organs of government, while also disrespecting the constitution of the land. Is there a way that the powers of the executive can actually be practically trimmed so that the executive does not derogate from its constitutional mandate? This seems to have completely failed in most African jurisdictions. And number 2, isn't shifting the burden of proof on the Electoral Commission and the election winner taxing on the commission and the candidate elect who is enjoying the fruits of his election strategy?
Thank you, Linda. The first question is about the commission of criminal offense during the electoral process. And according to the inquiry, whether or not the election court should not punish the offender. It should be remembered that the election court is not a criminal court, where the standards and the nature of materials that are presented before a criminal court are given with a lot of latitude, with a lot of time for cross-examination of the witnesses. That's why in electoral disputes, the election court can only make a finding that in its view, a prima facie case has been established of commission of an offense. So in that case, and the courts have expressly stated that the other agencies like the police and the DPP are called upon to further investigate and deal with that case. So it is not right to say that the offender should be left without punishment if all the agencies involved do their work. The second question was about the boycott of the second election in Kenya. Your guess is as good as mine as to whether or not it amounted to a boycott or not an election. So I leave it at that. The third question is about the excessive powers of the executive. I have already said that the executive has, in most cases, assumes powers far more than it is given by the Constitution. It is the duty of the court, when complaints are raised, to limit the executive and the other arms of government to their lanes. So that's why I'm calling upon the judiciaries in cases like this one, where if the executive is not called out, it will continue flouting the law and the elections will lose legitimacy. And we all know that once the populace has no faith in the elections, chances are that you are going to descend into conflict, and that should be avoided. So where and not only the executive, even the legislative arm and the judiciary should never exceed the powers they are granted by the Constitution. The other arms of government should call upon those who are exceeding to keep to their lanes. Thank you.
Thank you, Chief Justice.
The third one was about shifting the standard of proof.
Correct.
I said that some of the proof required relates to the election material, which are in the custody of the Electoral Commission. So where a prima facie case has been established, where it has been shown that there is a problem here, and as shown properly, then the burden should shift to the Electoral Commission to prove that no, what you are saying are irregularities, they were not even committed. And if they were committed, they were localized to say 1 or 2 polling stations, and they did not affect the result of the election. So, and that is what the Supreme Court of Kenya has stated, and I think reasonably so, that remember, this election is a legitimate process. If it is not done and properly and seen to be done properly, the public will not have faith in that electoral process. And as I've said, if there is no faith in an electoral process, we are bound to get into problems. Thank you.
Thank you, Chief Justice. We have a question from Amina Nyabuti. Good evening, Chief Justice Emeritus Maraga. Superb presentation. In your analysis of Section 83 of the Election Act, and arguably throughout your presentation, you seem to favor jurisprudence that focuses on integrity of the electoral process. This position of the presidential election petition of 2017, this is the position of the presidential election petition of 2017, which the Supreme Court nullified. However, it appears that the Supreme Court in subsequent decisions, which presented similar circumstances where the integrity of the electoral process was questionable, like the Wavinya Ndeti case, the Supreme Court surprisingly upheld the incumbent's victory. Is the jurisprudence sustainable outside of academic circles? I think that's in reference to the nullification. Could it be that the courts have developed cold feet towards this jurisprudence? Or could it be that the Supreme Court was experimenting with its jurisprudence? A question from Akin Oluwadaisi. My question, considering the nature of political will and pressure in electoral disputes adjudication, what would you advise the judiciary in terms of financial autonomy and judicial recusal? And I'll add to that my own personal question, which is, you had made reference to judicial courage. How important is it and where do you get yours? Martin Luther King once said, courage is the power of the mind to overcome fear. How can we get more judges to have courage?
Thank you, Lindia. The first question is on the integrity of the electoral process, and according to the commentator or the questioner, is that the courts seem to be vacillating and not being consistent in their jurisprudence. I don't remember, or I have not seen the judgments referred to. But if there is any waiver, that should be looked at. And in such a cases, in subsequent cases, those decisions which are not consistent with the Supreme Court decision should be reversed. If the decision is by the Supreme Court itself and the Supreme Court is not consistent, that should be brought to its attention, and I'm sure it will reverse itself and correct the position. Financial autonomy is an independent, one of the critical aspects of independence of the judiciary. The reason for this is that when the judiciary has funds, it is able to run its affairs without begging any other arm of government. So it is the duty, or it is the obligation of the nation, if they want an independent judiciary, to ensure that the judiciary is facilitated. Linda, you talked about courage. I can't give you an answer. It is upon all the judges. But in my presentation, you will recall, I said that a judge, particularly one called upon to adjudicate such an important litigation, is a call upon to rise above the fear and put himself in the position of the people who are going to be adversely affected by his decision if it is not correct. If, for example, because a judge is timorous, he or she shuts his or her eyes to an obvious thing and upholds, for example, an illegal election, the consequence, as I've said, is likely to be chaos in a country. For me, if there are chaos arising from a situation like that, and say somebody is killed, in my view, I would have committed murder if I occasioned that. That, in my view, is cardinal, and in my conviction, in my conscience, if I allowed that, and as a result of that illegal act, people die, I don't think I can live with that conscience. But so it is on individual judges to understand the enormity of the responsibility before them and to discharge it as they are required. I didn't mention, if the judges find that the petition is frivolous, it is their duty to say so and they dismiss it. It is not, I'm not talking about, or I'm not, let me not be misunderstood as saying that the courts should now turn around and upset elections in every case. Thank you.
Thank you. There's a question from Namibia from a Mr. Pickering, who believes that the judiciary in Namibia are not independent. And he's proposing that perhaps what needs to happen in Namibia is the creation of a Privy Council based in South Africa. And he wanted your comment on that. I also have two other questions. Have you read the Malawian judgment nullifying the 2019 elections? And what did you think of it? And you mentioned attacks on the judiciary, which were experienced as you were adjudicating over the presidential petition. What is the role of the Law Society in protecting the judiciary from attacks that infringe on judicial independence?
Thank you. The first question is about whether or not the Namibia should have a further appeal to the Privy Council. I will not be able to comment on that because I don't know, I'm not familiar with the legal framework in Namibia, whether it allows appeals to the Privy Council. That I'm afraid I cannot be able to answer. The case of Malawi, yes, I've read the judgment, and as far as I'm concerned, it is a wonderful judgment. It develops further even beyond what the Kenyan court developed. And I want to applaud the judges who made that decision, that courageous decision. It shows that we are becoming of age, and we are called upon to do the right thing. And as I said, if a petitioner comes with a frivolous petition, the court should dismiss it. But where a petitioner comes with a substantive petition and there is proof, the courts have no option but to nullify them. On the attacks, your question whether or not the Law Society has a role, I mean, it has a huge role. And I think, if my recollection is right, the Law Society condemned the attacks on the judges. It is one of the institutions which condemned the attacks on the judges. A few judges also, I mean, the denominations also condemned the attacks. As I said, it is the civic duty of the public to defend the judiciary. Because at the end of the judiciary, who is I mean, at the end of the day, who is the judiciary serving? It is the public. When you have no independence of the judiciary, it is not the judges who suffer. It is the ordinary people who get to court and cannot get relief because there is no independence of the judiciary. So that's why I'm urging the public to defend the judiciary so that you have law and order in the country. Thank you.
Thank you. I'm afraid that's all we have time for in terms of questions.
Yes.
We have unfortunately run out of time. I'm sure we could have gone on for hours in this very important and interesting topic, which the Chief Justice has so well articulated. But we have to wind up now, and I will now invite the Commonwealth Lawyers Association Council member from Kenya, Mrs. Maria Mbeneka, to give a vote of thanks to the Honorable Chief Justice.
Thank you, Linda. Thank you for this opportunity. I'd like to thank my Lord, the Chief Justice Emeritus, for a wonderful and thought-provoking lecture this evening. I'd like to say, indeed, there is wisdom in experience, and it is clearly evident from this lecture. Just a few, maybe to recap what stood out for us, or for me personally, listening to you. You spoke very well about the role of the judiciary and you know, where it is basically to adjudicate disputes and address at the same time the society's expectation. And I thought that was a very, very pertinent point. You also pointed out to the fact that the law is a living organism that is constantly changing. And in a democracy such as ours, and one would hope across Africa, the role of the judge is to protect the rule of law. So those are words that I found very, very poignant and very important to us listening to you today. You also spoke about the importance of adjudication of election petitions and the need to recognize the people's power, you know, when they're electing their leaders, and how that correlates with the ultimate role of the courts in deciding election petition. And my Lord, you also further spoke about the courts having a responsibility to reflect the law as the will of the people. My Lord, you forgive me, when you talked about the 4 doctrines, you mentioned, I got 3, perhaps I wasn't quick to catch the 3rd one, but you spoke about the 4 doctrines while you're addressing the courts, or the role of the election court, and specifically the Supreme Court. And you said that the role of the court is to re-examine the court's previous decisions. You talked about the second being the recalibration of standard of proof. And you know, you dwelt on this quite in detail. And you also spoke about technicalities versus substance being the 4th doctrine. And when you were addressing standard of proof, I think there was no doubt about where you stand when it comes to standard of proof and, you know, the best practice. And, you know, of course, pointing out that the election court is not a criminal court, and the work of the court is not to determine the criminality. I beg your pardon, but that the determination of criminality is left to other agencies. You also spoke about Section 83 of the Elections Act when you were looking at the substantive effect rule, and that was a very, very, very interesting application of the law when you were looking at whether, you know, to apply the 2 limbs disjunctively or conjunctively. My Lord, the Chief Justice also spoke about technicalities and how you were criticized roundly about ignoring the numbers but focusing on technicalities. And you explained to us what the court found to be the problem, and mainly you zeroed in on the counting and the tallying process, which is also quite critical, perhaps even for lawyers when they're addressing or representing their sides, what they should focus on in addressing election petitions. And you spoke about transparency and went back to Section 83 of the Elections Act in addressing this issue of counting and tallying, and talked about in the outcome of the 2017 presidential election, where there was an absence of electronic transmission of the results. This was not a mere procedural irregularity, but you found that the irregularities committed in the conduct of that election put the integrity of the entire election to question. And that is how the court arrived at the decision to nullify the election. Finally, my Lord the Chief Justice spoke very passionately about the attacks on the judiciary and judges and the public attacks on judicial officers, how that erodes the rule of law and weakens public confidence in courts and the independence of the judiciary, and I couldn't agree more. My Lord, it was a distinct pleasure listening to you. This lecture has to be taken from your personal perspective, and I think you were able to deliver that quite eloquently, not just as the head of the judiciary, but as a judge sitting during a very difficult time and very, very important instances when matters were referred to the Supreme Court for interpretation. My Lord, you were also able to bring out the importance of the judiciary as an important arm of the state. Ladies and gentlemen, this lecture has given us the insight of not just a judge, but a leader who had not only the responsibility to provide direction and leadership of an institution, but also to provide direction to the entire country following a hotly disputed election within a limited timeline. We salute you, my Lord the Chief Justice, and we wish you the very best in your retirement, and hopefully we'll be able to engage more. Allow me to hand over back to Ms. Linda Kasonde. Asante sana.
Thank you,
Maria,
for
those remarks. Thank you. Thank you very much. I'm honored to have participated in this first lecture. Thank you.
Thank you. That was an excellent vote of thanks. And just to close, I'd just like to thank the Honorable Chief Justice Emeritus David Maraga once more for that illuminating presentation. As Maria mentioned, it's nice to see, to hear the thoughts behind somebody who had held that leadership position, and your views on presidential petitions and judicial independence. I'd also like to thank all the panelists who've participated in this program. Thank you to Maria Mbaneka for her vote of thanks. And thank you to the Secretariat of the Commonwealth Lawyers Association. Again, we'd like to invite you to become members of the Commonwealth Lawyers Association. Please do check our website for further details. And also we welcome you to join our biennial conference in the Bahamas in September this year. Thank you once again, and have a pleasant evening all. Thank you.
Thank you. Thank you very much.